Hello, viewers. At the very outset, I would say to shut up a man in prison longer than is necessary is not only bad for the man himself, but also it is a useless piece of cruelty, economically wasteful, and a source of loss to the community. So, dear listeners, warm greetings of the day. In the first part of this theme, that is kinds of punishment, we have discussed the meaning, nature, rationale behind the sentencing policy and how the crime impacts the punishment. Now we shall be talking about the different kinds of punishment as prescribed under the Indian Penal Code 1860. So with this, we get started. Crime and punishment are interdependent. The modern penal policy is not devised on a straitjacket formula. Diversity in crime is also reflected in the sentencing policy. Starting with the Indian Penal Code 1860, the most important substantive criminal law of India, punishment is dealt in Chapter 3. This chapter contains sections 53 to 75. Different kinds of punishments have been incorporated for different offences depending upon their severity. Listeners, before the rise of humanitarianism in the penal philosophy, mutilation, branding, and flogging were well recognized modes of punishment. In India, the corporal punishment of whipping was first added and regulated by the Whipping Act of 1864, and this was repealed and replaced by the Whipping Act of 1909, and it was abolished in the year 1955. Now in England, flogging was abolished quite some time ago. Such a punishment was considered as barbarous act, a stain on civilization, and a blot on the statute book. Now, at the very beginning, we shall be analyzing Chapter 3 of the Indian Penal Code that deals with punishments. Section 53 of the Indian Penal Code 1860 provides the punishments to which the offenders are liable under the provisions of this code. Dear viewers, under the IPC, punishment is under the following heads. We start with death, the punishment of death. Then we have imprisonment for life, imprisonment which is of two descriptions, namely rigorous, that is with hard labor, or simple imprisonment. Then we have forfeiture of property, and the last form of punishment is fine. So, starting with the most serious form of punishment, that is death sentence. Now, death sentence or capital punishment refers to the justified death of the wrongdoer after following the due process of the law. Capital punishment connotes a method of legal vengeance whereby the wrongdoer is subjected to the most extreme form of punishment. This kind of punishment can be awarded only in the rarest of rare cases. Under the Indian Penal Code 1860, death sentence has been incorporated as an alternative form of punishment for serious offences enumerated in the following sections. So, starting with section 121, waging war against the government of India, section 132, abetment of a mutiny when it is actually committed, section 194, giving or fabricating false evidence whereby an innocent suffers death, section 195A, threatening any person to give false evidence, resulting in conviction and death of an innocent person. Section 302, that is murder, punishment for murder. Section 305, abetment of suicide of a minor, insane and intoxicated person. Section 307, attempt to murder by live convicts if hurt is caused. Section 364A, kidnapping for ransom. Section 376A, rape causing death or resulting in persistent vegetative state. Section 376E, second or subsequent offence punished under Section 376, 376A or 376AB or 376D or 376DA or 376DB. Then we have Section 396, that is dacoity with murder. Now coming to the constitutional perspective, the constitutional validity of capital punishment has been challenged as being violative of the right to life. The judicial perspective through a catena of case law leans in favor of awarding capital punishment as a form of punishment only in the rarest of rare cases. Death penalty as a form of punishment was retained. However, in the case of Lakshma Devi versus State of Rajasthan, public hanging was declared as unconstitutional. Dear listeners, it is very important for us to understand that death sentence as a form of punishment has remained a debatable issue. Its efficacy has time and again been questioned. Desirability of this form of punishment vis-a-vis the reformative approach to punishment has been viewed from different perspectives: individual, victim, society, criminal, penal and judicial. Most recently, by way of the Criminal Law Amendment Act of 2018, the Indian lawmakers have increased the category of offences for which death sentence may be awarded. Thus, a clear dichotomy can be witnessed here, as on one hand, most of the countries are abolishing the death sentence, whereas India has actually increased the ambit and scope of this form of punishment. The popular public opinion is strongly in favor of retention of capital punishment for serious offenders, rapists and terrorists. In the recent past, Ajmal Kasab, the lone surviving terrorist of the Mumbai carnage, was executed for waging a war against India. Listeners, it is noteworthy that the Indian Penal Code under Section 54 provides for commutation of sentence of death. It provides that in every case in which sentence of death shall have been passed, the appropriate government may, without the consent of the offender, commute the sentence for any other punishment provided by this code. Significantly, Chapter 32 of the Code of Criminal Procedure 1973 deals with the execution, suspension, remission and commutation of sentences. It is very important for us to note that Section 433 of the Code of Criminal Procedure 1973 deals with the power to commute sentences. Here the appropriate government may, without the consent of the person sentenced, commute, first of all, a sentence of death for any other punishment provided by the Indian Penal Code 1860. Secondly, a sentence of imprisonment for life for imprisonment not exceeding 14 years or for fine. Third, a sentence of rigorous imprisonment for simple imprisonment for any term to which that person might have been sentenced or for fine. And lastly, a sentence of simple imprisonment for fine. With this, we come to the second part, that is imprisonment for life as a mode of punishment. Dear listeners, in life imprisonment, the convict has to serve imprisonment for the remaining part of his or her natural life. Life imprisonment is always rigorous. As per section 57 of the Indian Penal Code, the period for life imprisonment is 20 years, only for calculating purposes. It is prescribed for offences under sections 121, 121A, 132, 194, 302, 304, 326A, 364, 364A of the Indian Penal Code 1860. Here it is important to note that section 53A was inserted in the Indian Penal Code by way of the Code of Criminal Procedure Amendment Act 1955 in order to abolish transportation for life as a form of punishment and substitute imprisonment for life in its place. The sentence next to death in gravity was transportation, which is another name for punishment by exile. Interestingly, during the British rule, such prisoners were generally sent to the Andaman and Nicobar Islands. Now coming to the apex court ruling in Gopal Vinayak Godse versus State of Maharashtra, it was held that a person sentenced to transportation for life or any other term before the enactment of the impugned section was to be treated as a person sentenced to rigorous imprisonment for life or for a lesser period as the case might be. Now viewers, we come to section 55 that empowers the appropriate government to commute the sentence of imprisonment for life to imprisonment of either description for a term not exceeding 14 years. Section 433 of the Code of Criminal Procedure deals with the power to commute sentences. Further, Section 433A was inserted by the Act 45. This section deals with the restriction on powers of remission or commutation in certain cases. Interestingly, it has lent more clarity to Section 433 of the Code by stating that, notwithstanding anything contained in Section 432, where a sentence of imprisonment for life is imposed on conviction of a person for an offence for which death is one of the punishments provided by laws, or where a sentence of death imposed on a person has been commuted under Section 433 into one of imprisonment for life, such person shall not be released from prison unless he has served at least 14 years of imprisonment. In Munna versus Union of India, the Supreme Court held that life imprisonment could not be treated as 14 years or 20 years without there being a formal remission by the appropriate government. Section 57 of the Indian Penal Code states that in calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent for 20 years. Now, we shall come to the third part of the kinds of punishment, that is rigorous imprisonment. Viewers, the Indian Penal Code has further classified imprisonment into simple or rigorous. As the name suggests, rigorous imprisonment means imprisonment with hard labor. The convicts are paid wages for the work done by them in the jail, and it is given under sections 194, 376, 376A, 376AB, 376C, 376D, 392, 393, 394, 395, 396, 398, 399, to name a few sections from the Indian Penal Code. In the case of Phul Kumari versus Office of the Superintendent, Central Jail Tihar, New Delhi, it was observed that rigorous imprisonment is one which is required by law to be completed with hard labor. While a person sentenced to simple imprisonment has the option of choosing to work, a person sentenced to rigorous imprisonment is required by law to undergo hard labor. So this is how we can differentiate simple imprisonment from rigorous. In K.M. Nanavati versus State of Maharashtra, it was held that imprisonment for life means rigorous imprisonment, that is till the last breath of the victim. Now coming to simple imprisonment. In simple imprisonment, the convict prisoner is kept in prison without doing any hard labor. It is the lodging of the prisoner inside the prison with only light duties, and such convicts are not required to do any hard labor. This can be given in the jail on the basis of their request and physical fitness. It is awarded in offences under sections 169, 172, 173, 174, 175, 176, 178, 187, 188, 223 of the Indian Penal Code. Now, here it is important to state that under section 60 of the Indian Penal Code, the sentence may be in certain cases of imprisonment wholly or partially rigorous or simple. This section states that in every case in which an offender is punishable with imprisonment, which may be of either description, it shall be competent to the court which sentences such offender to direct in the sentence that such imprisonment shall be wholly rigorous, or that such imprisonment shall be wholly simple, or that any part of such imprisonment shall be rigorous and the rest simple. Coming to the next form of punishment, forfeiture of property. Forfeiture of property implies the loss of property by the accused by the state action. The state is legally empowered to seize the movable or immovable property of the wrongdoer. Section 126 of the Indian Penal Code, that deals with committing depredation on territories of power at peace with the Government of India, provides for forfeiture of any property used or intended to be used in committing such depredation or acquired by such depredation. Similarly, under section 127, receiving property taken by war on depredation mentioned in sections 125 and 126 also attracts the punishment of forfeiture of the property so received. Furthermore, under section 169 of the Indian Penal Code, if a public servant unlawfully buys or bids for property, and if such property is purchased, it is liable for confiscation. Now coming to the last form of punishment, we have fine. Section 63 of the Indian Penal Code deals with the amount of fine. It states that where no sum is expressed to which a fine may extend, the amount of fine to which the offender is liable is unlimited but shall not be excessive. The amount of fine is either fixed by the Indian Penal Code or it can also be decided by the court. The amount of fine is fixed by taking note of the financial condition of the convict and is not to be excessive. In the case of Ashok Kumar versus State, the Supreme Court observed, payment of fine brings home the sense of responsibility in a surer fashion than even short terms of imprisonment in some cases. A situation where the offender fails to pay the fine is covered by section 64. This section provides that in every case of an offence punishable with imprisonment as well as fine, in which the offender is sentenced to fine, whether with or without imprisonment, and in every case of an offence punishable with imprisonment of fine or with fine only, in which an offender is sentenced to a fine. In both the above cases, it shall be competent to the court which sentences such offender to direct by the sentence that in default of the payment of the fine, the offender shall suffer imprisonment for a certain term, in which imprisonment shall be in excess of any other imprisonment in which he may have been sentenced or to which he may be liable under a commutation of sentence. Section 65 further provided the limit to imprisonment for non-payment of fine, when imprisonment and fine are awardable. It is specifically provided that the term for which the court directs the offender to be imprisoned in default of payment of fine shall not exceed 1/4 of the term of imprisonment, which is the maximum fixed for the offence, if the offence be punishable with imprisonment as well as fine. Furthermore, under section 66, the imprisonment which the court imposes in default of payment of fine may be of any description to which the offender might have been sentenced for the offence. Here, it is important to note that under section 67, if the offence be punishable with fine only, the imprisonment which the court imposes in default of payment of the fine shall be simple, and the term for which the court directs the offender to be imprisoned in default of the payment of fine shall not exceed the following scale. That is to say, for any term not exceeding 2 months, when the amount of the fine shall not exceed 50 rupees, and for any term not exceeding 4 months, when the amount shall not exceed 100 rupees, and for any term not exceeding 6 months in any other case. Now, section 68 states that the imprisonment which is imposed in default of the payment of fine shall terminate whenever that fine is either paid or levied by the process of law. Now, with this, we complete with the kinds of punishment. Now, we shall be talking about a very important and sensitive aspect of sentencing, that is solitary confinement. As its very name suggests, solitary confinement refers to keeping the prisoner in isolation. This form of punishment is meant to be used to deal with disruptive prisoners who are a risk not only to the fellow inmates but also to the prison staff. However, the court can grant this form of punishment only for those offences which are punishable with rigorous imprisonment. In the case of Kishore Singh Ravinder Dev versus State of Rajasthan, the Supreme Court held that solitary confinement or putting fetters could be imposed only in exceptional cases for security reasons. Flimsy grounds like loitering in the prison or behaving in an uncivilized manner, tearing off his history ticket cannot be the foundation for the treatment of solitary confinement and crossbar fetters. As per the Indian Penal Code, in no case the sentence of solitary confinement may be imposed for more than a period of 14 days at a time and must be imposed in intervals. Now, coming to section 29 of the Prisons Act 1894, no cell shall be used for solitary confinement unless it is furnished with the means of enabling the prisoner to communicate at any time with any officer of the prison, and every prisoner so confined in a cell for more than 24 hours, whether as a form of punishment or otherwise, shall be visited at least once a day by the medical officer or the medical subordinate. Listeners, now we shall be coming to the limit of punishment of offences made up of several offences. The sentencing policy specifically takes note of a situation where anything which is an offence is made up of parts, any of which part is itself an offence. The offender shall not be punished with imprisonment of more than one of his offences unless it be so expressly provided. Now, section 71 states that where anything is an offence falling within two or more separate definitions of any law in force for the time being, by which offences are defined or punished, or where several acts of which one or more than one would by itself or themselves constitute an offence, when combined, a different offence, the offender shall not be punished with a more severe punishment than the court which tries him could award for any one of such offences. We come to the next part, enhanced punishment in case of certain offences. Section 75 provides for enhanced punishment in case of a person has already been convicted of an offence punishable under Chapter 12 and Chapter 17 for a 3-year term of imprisonment or more, if found guilty of committing the offences again under the said chapters, would be liable to punishment up to imprisonment for life or up to 10 years. So, concluding the whole session, I would like to say that punishment is a designed social reaction to crime. It is a human act and involves deliberate infliction of suffering on the wrongdoer. It is an institutionalized suffering. The attitude of the society towards the criminal has been governed by the emotions and traditions prevalent in a given society. The infliction of suffering on the criminal provided a sense of relief or gratification to the members of the society. The impulses of human mind get a sense of satisfaction by inflicting punishment on the wrongdoer. With this, I come to an end of this session on the kinds of punishments. Thank you very much for patient hearing. Thank you.